Welcome and good afternoon, everyone. This is the first installment of our Special Asset Summer School series. And if you guys have been joining us for a few years now, you know that I always say that summer doesn't get started until the Special Asset Summer School series kicks off. So now it feels like summer. If the heat outside in North Carolina wasn't doing it for us. This class is going to be led by Lily Faulkner and Lance Martin, and we are going to explore the power of mechanics of receivership and what lenders can expect if one is put into place. So we'll go ahead and welcome them. My name is Haley Cook. I'm the marketing coordinator of events and sponsorships here at Warden Smith in our Wilmington office, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try and troubleshoot with you. This webinar is being recorded and it will live on our website. So if you miss it or if your friend couldn't make it, it will live on our website under past events or past webinars. And you can even go on deep into the archives to see previous years, but those will be recorded and shared there. Our speakers are happy to take questions during this webinar. If you have a question, please type it into the Q&A box and it will be addressed at the conclusion of the presentation. As I mentioned, today our speakers are Lily Faulkner and Lance Martin. They are both creditors' rights attorneys here with us at Warden Smith, and I am going to turn it over to Lily to get us started.
Thanks, Haley, and good afternoon, everyone. As Haley said, my name is Lily Faulkner. I am a creditors' rights and business attorney here at the firm. Have the pleasure of working with many of you before, and am really excited to be here with Lance today to talk to you about receivership. So we'll go ahead and turn it over to Lance so that he can kick things off.
Thank you, Lily. Good afternoon, everyone. Thank you for joining us. For those of you who I don't know, we haven't met before. My name is Lance Martin. I've been practicing at Warden Smith for 27 years now, and most of that has been with bankruptcy and creditors' rights issues like collection, foreclosure, workout, receivership, etc. And so today we want to talk about North Carolina Commercial Receivership Act, which celebrated its 5-year birthday this year. Before the Receivership Act was put in place, we had a very antiquated and primitive statute that no one used. But in 2021, the North Carolina legislature enacted a very robust statute, which is essentially bankruptcy in state court in a lot of ways. And we've had enough cases over the last 5 years to kind of understand what's good about it, what's challenging about it, and how it compares to bankruptcy, either Chapter 7 or Chapter 11 bankruptcy. And today we kind of have a case study, and Lily and I are very excited to talk about this because we're nerds. But it involves a case that's going on across the border in Tennessee for the past year, and that is the company called Uncle Nearest. And Uncle Nearest, why don't we go to the first slide, Haley? Yeah, so Uncle Nearest started as what your colleagues in the commercial lending side of the bank would get really excited about. It was, by all accounts, a very successful company that distilled whiskey. It was founded in 2017 in Shelbyville, Tennessee. It had a great story behind it. Its literal secret sauce had come from a gentleman named Nathan Nearest Green, who, as the lore would have it, had taught Jack Daniels how to make whiskey, Tennessee whiskey. So it had a great story. It had a very charismatic and social media savvy president and a lawyer. Her name is Fawn Weaver. She's a Vanderbilt Law grad. And by 2021, it was the fastest growing American whiskey brand in the United States. 100 million in sales into late 2022. It was sold in all 50 states, 12 countries. At its peak, it had a valuation of over $1 billion. It was raising capital. A lot of people were going to the distillery to visit, and Miss Weaver was she was being recognized in print media like Time Magazine. I think she was on Oprah. She's very active in social media. She was hailed as, this incredible entrepreneur, um, putting out a very popular and successful product in an industry that to a large extent is primarily male. So it was a great story, and I'm sure the bankers were excited to have the lending relationship. Unfortunately, that was the label on the barrel, but when you went inside and looked into the barrel, there was a disconnect. So why don't we go to the next slide? So in the course, our victim here is a lender called Farm Credit Mid-America, and they were the primary secured lender for Uncle Nearest. And in the course of their lending relationship and doing their periodic monitoring and knowing their customer, they started to discover some troubling issues. Number one is, the top of the balance sheet in terms of assets was inventory, barrels of whiskey, and those were being overstated considerably. So it was discovered that north of 20 million in inventory didn't exist. They also discovered that the company was selling collateral out of trust. You've all likely dealt with this before. Selling collateral or pledging collateral out of trust. So not only were there not all the barrels there that Form Credit thought it had, some of the barrels had been sold to take care of other creditors, not to service Form Credit's debt. There was a lack of financial transparency, and we put on the slide, financial chaos. Not doing the basic things you're supposed to do, like file your tax returns. So we're talking about 4 years of tax returns that hadn't been filed. We've got revenue being overstated on the balance sheet. Basically, the borrowing base certificates weren't worth the paper they were printed on. And then on top of that, you've got what we could kindly say is ownership not being good stewards of the company's assets by, for example, using company funds to purchase a vacation home on Martha's Vineyard. So as this is coming to light with Farm Credit, the company has debt of north of $220 million. They're burning through $1 million per month. It's a real problem. So here's what Farm Credit did. Let's go to the next slide. So by July of 2022, you've got a $55 million credit facility. This had been amended several times through loan modification agreements and otherwise until we get to January of 2025, so about a year and a half ago. At that point, Farm Credit's owed $65 million plus the borrowing base, the best they can tell, the company has $44 million in assets. So north of 20 million shortfall that Uncle Nearest and its ownership can't repay. So they put him under a forbearance agreement to see if they can't work this out directly. Um, that is a band-aid that does not solve the problem. And, by July, the bank has got their lawyers involved. They've filed a federal court lawsuit in Tennessee. And what they are asking the judge to do is to appoint a receiver over the entire company. Um, Less than a month later, the court does appoint a receiver, and I believe the receiver is a lawyer. And so he is appointed, and the receivership order gives him complete control over all the corporate entities that comprise the Uncle Nearest Distillery operation. He's vested with the authority, all the powers of an officer, director, membership, management. It is basically a wholesale replacement of the current management of the company. Crucially, he's given the express and exclusive authority to put Uncle Nearest in bankruptcy if he thinks it's in the best interest of the company and the creditors. And then the judge sort of admonishes Mrs. Weaver and former ownership that they're not to interfere with the receiver. They're supposed to sit on the sidelines and let him do his job. Um, so it's very clear that we have replaced ownership and control is now solely vested in the receiver. This case came to our attention, Lily and I, because um, Ms. Weaver disregarded what the court ordered, and a few days after the receivership order was entered, she filed a bankruptcy petition on behalf of Uncle Nearest, attempting to put the companies in Chapter 11. And why would she want to do that? Because, as all of you are probably aware, if you've ever had to go through a Chapter 11 process, the debtor is in charge in Chapter 11. They are called the DIP, the debtor in possession, and they run the show in bankruptcy to a large extent. They have time to file a plan of reorganization. They continue to manage the company in bankruptcy in the absence of conversion or otherwise. So, in an attempt to maintain control of her company, she filed a Chapter 11 bankruptcy. So there was this question that the courts had to answer. Who's right? Who's in charge? Is it the receiver, the court-appointed receiver, or is it Mrs. Weaver and Uncle Nearest in Chapter 11? Um, so this was not a hard question for the bankruptcy judge. The bankruptcy petitions were filed on March 17th. The receiver had essentially emergency TRO hearing 2 days later, and the bankruptcy judge summarily dismissed the bankruptcy filings. And he pointed to the receivership order that had been entered that said that there was only one person after that order was entered who had the authority to file bankruptcy for the companies, and that was the receiver, Mrs. Weaver. no longer had the authority to do so. So the bankruptcy case was dismissed. It returned to the receivership, and Mr. Young has been working for the past year and a half to try to salvage whatever value there is in the company, investigate all the financial and corporate malfeasance, and try to sell it off as a going concern. And ironically, I think last week, Mr. Young filed a motion in the case to sell the company as a going concern to a third party entity, and that is being going to be considered by the court in the next couple of months. So that is generally what happened over there in Tennessee. And what we're going to do now is transition to our North Carolina Commercial Receivership Act to talk to you about if you had a scenario like this here in North Carolina, here's what you can and can't do under our act. And so now I would turn it over to my colleague, Lily.
Thanks, Lance. So as Lance said, we're going to focus on the North Carolina Commercial Receivership Act, which, again, as Lance said, is celebrating its 5th birthday this year. So under the new North Carolina Receivership Act, if you're a lender and you want to pull the lever, you want to initiate a receivership, first you need to make sure that your debtor qualifies under the act for receivership. So who can be a debtor under the act? Of course, entities. So that's corporations, limited liability companies, partnerships. But individual business debtors may also be debtors under the Receivership Act and subject to a receivership filing. An individual business debtor is an individual whose consumer debt is less than 50% of the total debt on the filing date. So if you have a consumer debtor or an individual whose consumer debt is greater than 50% of their debt, they are not going to qualify for a receivership under the Act. The Act also does not apply to estates, trusts that are not business trusts, or state agency receiverships. So we're really focused only on business entities and individual business debtors. A lender may initiate a receivership before judgment in North Carolina, as well as post-judgment. If you initiate a receivership before judgment in North Carolina, you're going to be initiating what's called a limited receivership, and we'll get into that a little bit more shortly. That is going to occur when there is an apparent right or interest in your collateral that is threatened by some kind of loss or avoidable transaction, or typically when you're going to see a pre-judgment receivership initiated. And then post-judgment, you may initiate a limited or a general receivership under the statute. And typically that's going to be to carry your judgment into effect, to preserve property pending an appeal, or if your execution is returned unsatisfied, you may want to initiate a receivership if you're aware of assets that are available to satisfy your judgment, but are kind of struggling. So you need to meet some qualifications in order to be entitled to a receivership. If you would like to initiate a receivership for an entity or an individual business debtor on insolvency grounds, that's pretty straightforward. Obviously, insolvency is a factor that the courts considered, not paying debts as they become due, danger of insolvency. So if the company seems to be on the brink of becoming insolvent and you want to stop that, certainly a grounds for initiation of a receivership. Of course, if the business is suspended because they don't have funds to operate or dissolved, forfeited, expired with their obligations, those are all grounds to initiate a receivership for entities and individual business debtors. If you're a secured creditor in a foreclosure or an enforcement action, you may also initiate a receivership for those instances that I just discussed where your right in your property is threatened, right? Your collateral is in danger of waste or loss or dissipation. Impactfully, if the debtor consented in writing in your loan documents, you may rely on that to initiate a receivership. You may also initiate a receivership if the collateral is not sufficient to cover the debt that's owed, if the debtor fails to turn over the collateral, or if a junior lien holder has already obtained a receiver. So, as a practice pointer, really important to put into your loan documentation authority to appoint a receiver upon default. That will immediately pretty much satisfy your burden of proof. And so, going to be pretty easy if the documents show the court that you're entitled to appoint a receiver upon default of your debtor. So, how
Lily,
do
and
you?
If I can just jump in too, I think that most of your form loan documents would have an assignment provision and a right to a receiver provision. But if it doesn't, this is the type of provision that we would advise to slip into a forbearance agreement or a loan modification agreement, because usually receivership isn't the first step in the process. It's usually after some sort of workout period, but it would be worth it to forbear even for a short period of time to get a provision like that, because it's the first thing you can point to when you go into the court and ask the judge to appoint a receiver, that through the virtues of freedom of contract, the borrower has agreed to this in consideration for the loan or in consideration for some sort of forbearance. And that goes a long way. I would also say that you have to be very hesitant to push for receivership if you're dealing with an operating solvent company, a general receivership that would wrest complete control of the company from current ownership. The courts are going to be reluctant to grant that kind of relief if you're dealing with a company that's doing okay everywhere else except as to your obligation. And that's the kind of thing you really want to consult with your counsel about before going forward with trying to get a general receiver in place as opposed to a limited receiver over just your collateral. Okay, sorry to interrupt, Lily. Oh,
No, thanks, Lance. And so, in the context of Uncle Nearest that Lance just discussed, if they didn't have those key provisions in their loan documents when they first entered into their forbearance agreement in 2025, they could have added those things in to allow them to take the actions that they later took to initiate that federal receivership. Similarly to Uncle Nearest in North Carolina, if you want to initiate a receivership, you typically file a complaint or a motion to appoint a receiver. And there are two ways that you can do that. The first is kind of a normal track where you provide 10 days notice to the debtor, other parties, and those other parties are going to be, parties with interest in your collateral, or parties you're aware of who may be entitled to notice. Again, that would be when you would consult with your attorney on who you need to notify of the motion to appoint the receiver. More often than not, though, it's going to be on an ex parte or an emergency track. And that is going to be available if an emergency is clearly shown and you can demonstrate that there will be irreparable harm if a receiver is not immediately appointed. And so that goes to what Lance was saying of this is not a remedy that you want to start with upon default unless it's clear that there are other really big issues with your obligor as far as insolvency and harm to your collateral or to the general business obligations if a receiver is not appointed. The court's going to hold a hearing if you move for an ex parte appointment as soon as practicable, and then the burden of proof at that hearing is going to be the same as if full notice is given. So court will take emergency action, but you've got to come back and justify everything that you've requested. And as I mentioned, Farm Credit moved on an emergency basis. And so that would be the same thing in North Carolina. If you needed some immediate relief, you can move for an emergency appointment under our Receivership Act. Haley, if you want to flip it to the next slide. So Lance and I have been mentioning the difference between a limited receivership and a general receivership. Not all receiverships are created equal. So under North Carolina law, a limited receivership is exactly what it sounds like. It is limited. It's going to cover specific identified collateral only. And importantly, any receivership that is based on foreclosure or enforcement of a lien where there is a statutory right of redemption, that is going to be a limited receivership under North Carolina law. If your receivership order does not specify whether it's a limited receivership or a general receivership, that's also going to be by default a limited receivership under North Carolina law. Excuse me. So under a limited receivership, because it's limited, the individual business debtor is going to retain certain rights. And that includes the right to file bankruptcy. So Lance was discussing earlier the issue that the bankruptcy court in Uncle Nearest had to resolve, which was who's in control and who has the right to make decisions for the business. In a limited receivership, typically management is going to be involved and be in charge of those business operations. The receivership is going to be limited specifically to certain collateral. So there's a retention of the right to file bankruptcy with management of that business. Additionally, in a limited receivership, the automatic stay, which we'll discuss more in a little bit, is going to be more narrow in scope than it would be in a general receivership. A general receivership covers all or substantially all of non-exempt assets of the business debtor, and it's going to completely replace management of the company with the receiver. So the receiver is going to step into the shoes of the management and run the company. Notably, the receiver is an agent of the court, right? So the receiver, even if you as the lender propose a particular receiver, the receiver is not your agent. The receiver is the court's agent. And so similarly, the receiver is not the agent of former management of the debtor. That is demonstrated in Uncle Nearest. The receiver that was appointed in that case was actually the choice of Ms. Weaver, the prior management. They proposed Mr. Young as the receiver. The court accepted that proposal. But eventually, of course, the Weavers and Mr. Young became adversaries because they had different ideas of what was best for the business. And there have been some comments since the filing that perhaps a receiver with industry experience would have been a better choice for broad management of the business operations. So that's something that you want to think about if you are thinking about pursuing a general receivership is who is going to make a good general receiver? Do they need certain industry experience? Do you want them to be experienced with a particular type of business strategy? Do you need a turnaround manager? Do you need a restructuring professional? Who is going to be the best person to accomplish the goals of that receivership?
Lily, if I can just jump in, I wanted to make a couple of points. So first of all, so limited versus general. Let's use an example. Suppose your loan is secured by an abandoned strip center. So your collateral is real estate, but it's abandoned. You don't have any tenants. So you're looking at foreclosing that property. So in an instance like that, you may be content with a limited receivership over the property. To just to preserve it, maybe keep it locked down, maybe have a guard oversee it or whatever, so that nothing happens to it till you can complete a foreclosure. And the trade-off there is that, well, the debtor could file a Chapter 11 bankruptcy and then try to buy some time to sell it itself, but you might be entitled to stay relief if they can't make adequate protection payments, and you get out of bankruptcy pretty quickly if there's no equity in the collateral, and then you can complete your foreclosure. If, on the other hand, your collateral is a strip center that's fully occupied, and rents are being generated, then you may want a general receivership, because then you step into the shoes of management. You can collect the rents, and you can get a receiver who can maybe market and sell this property as a going concern on your behalf, and it may have more value to you and an ability to get you paid in full through a sale that way. So it's one way of thinking about limited versus general. The other thing I wanted to point out is that if you ask for a general receiver and get one, uh, if you want to stay in the county where your collateral is located, where you filed your lawsuit, the courts will assign what's called a 2.1 exceptional case judge. And this is the exception to the rule that in North Carolina, state court judges, they what's called ride circuit. So different judges sit in different superior courts at different times. And over the life of a case, you might have several different judges who hear matters in your case. This is an exception to that. One judge with some business experience is assigned to your case. But if your problem is big enough, in other words, um, if your debtor has over $5 million in assets, and it's a corporate entity, then you can have your case designated as a mandatory complex business case. And so then it gets assigned to North Carolina Business Court. And in North Carolina, we have a specialized court system that's been around for 20 years for it primarily deals with corporate and commercial law matters, corporate governance, securities, antitrust, trade secrets, big contractual disputes. And we have 6 judges on the business court who handle these cases. And they're very smart, and they're very fluent in lending matters, corporate matters, business matters. So you can be guaranteed that you're going to have um, an intelligent judge to handle the matter through the life of the case. And then circling back to Lily's last point, which is about who makes a good receiver. So the first thing you need to keep in mind is that if you're seeking a receiver, um, you've got to make a recommendation to the court. You don't get to pick your receiver, but the court's going to look to you to make a recommendation. There's no like, the judge can't turn and signal to the bullpen for a receiver. There's no group waiting in the wings to be appointed. And you don't want a lawyer, what you want is the right tool for the job. So the company that you're putting into receivership, if it's a going concern, you want somebody who knows something about that industry. So in the case of Uncle Nearest, an ideal receiver would have been somebody with experience in the distillery business. If you want to put a receiver over a hotel, then you want somebody with hotel experience. We're involved in one right now in Henderson County. It's a partially constructed condominium development, but there's still tens of millions of dollars of construction that needs to be completed on this project. So there, if a receiver is appointed, you would want somebody with some project management and construction experience, because they are going to be running the company for some period of time, even if it's just to you get the company sold as a going concern. And if you don't, one of the big purposes of a receiver is to protect value, so that any enterprise value isn't completely dissipated before you can reduce your claims to judgment or foreclose or sell your collateral. And so to preserve enterprise value, you want somebody as a receiver who has some experience in the industry. Back to you, Lily.
Thanks, Lance. And to Lance's point, the court has to appoint the receiver, and they're not going to appoint a receiver that does not appear qualified in some way. And so the factors that the court will consider under the North Carolina Act for appointment of a receiver are the relevant knowledge and experience. There's a bond required for receivers under North Carolina law. So they're going to evaluate the ability of the receiver to post that bond. They're going to look at whether the receiver has been previously disqualified in any receiverships. If the receiver has any felony or moral turpitude convictions, those are not allowed. And also no civil liability for fraud or breach of fiduciary duty. And that makes sense. You don't want someone coming in to manage the company that has a history of maybe mismanagement. Similarly, receivers cannot be materially related to any party in the dispute. They can't have an adverse interest or any kind of arrangements or equity holders or ownership interest in a debtor, in the debtor, or in a creditor of the debtor, or any equity holder of any of those parties. So the court's going to evaluate that and appoint a receiver. What then? What can the receiver do once the receiver is appointed? Haley, if you'll flip to the next slide. All receivers under the Act can take possession, collect, control, manage, conserve, and protect receivership property. Of course, in a limited receivership, that receivership property is going to be limited, most likely to the collateral. So in Lance's example of that strip mall, that would be just the strip mall property that the receivership applies to and that the receiver is working to sell in a limited receivership. The receiver in a limited or general receivership can also incur and pay administrative expenses and assert claims and defenses related to the receivership property. And again, that property is going to be more expansive in a general receivership. In a general receivership, there are many more powers that are provided to the receiver under North Carolina law. The general receiver can sue and collect all debts in the debtor's name or the receiver's name. The receiver can intervene in pending actions. The receiver may sue on fraudulent transfers. So the receiver may bring claims under North Carolina's Voidable Transactions Act to recover fraudulent transfers in a certain time frame prior to the receivership being initiated. The receiver may also adopt or reject executory contracts of the debtor. The receiver may issue subpoenas and compel testimony and production from any person, including the debtor. And they also, as we've talked about at length, may operate and manage the business in the ordinary course. So that means that they can use, sell, lease, license receivership property in their role as receiver and as manager of the company. Crucially, under North Carolina law, as we've said, a general receiver may file bankruptcy without a board vote and without any approval from members, managers, directors, or officers of the debtor. So this is a statutory answer to the question that was posed in the Uncle Nearest case, which is who has authority. In North Carolina, that's going to be the general receiver under the statute. However,
And if I can jump in here, Lily, on this point, we bankruptcy lawyers love this provision because it provides a statutory alternative to involuntary bankruptcy. If you've been a special assets officer for any period of time, you may have likely have had the conversation with your counsel about, well, can we just put this company in bankruptcy? And there is statutory authority in the bankruptcy code to do so, but it is ingrained in us as bankruptcy lawyers to never try to do this. Um, it's a complicated process. You've got to round if it's a debtor of any size, with more than a dozen claims, as most big businesses would have. You've got to round up at least three petitioning creditors to kind of go in with you to file the petition. And sometimes that hurdle just can't be cleared. And it's kind of awkward. You got to go talk to other creditors about problems with your own loan, try to get them on board. You got to find them. You got to get a decision maker. But the bigger issue is that the code doesn't like involuntary bankruptcies. So the requirements are such that the debtor's not the test is like not paying debts as they become due, but the case law is like you have to do this holistic totality of the circumstances test. And is there a genuine dispute about some of the debts and whether they're contingent, or are they not being paid because there's a dispute about whether they're owed or not, or what amount? And the thing is that if you're wrong and the case is dismissed, you can be tagged with cost, fees, including all attorney's fees of the debtor, and like fees on fees. So if you fight it and you lose, the fees for them to fight you. And you can also get hit with punitive damages if a court determines that you filed the involuntary in bad faith. And there was a case a few years ago where the bankruptcy court awarded over 750,000 in damages to a debtor, when some private equity put them into involuntary. And the court found that there was no actual damages because the company was essentially had no revenue that it lost, but that they didn't meet the test for dismissal and it had been filed in bad faith. And so we don't like to file involuntary bankruptcies, unless there's absolutely no other alternative. But we have another alternative, this kind of two-step: get a general receiver appointed and then have the receiver put the entity into bankruptcy. Back to you, Lily.
Thanks, Lance. Haley, if you'll flip to the next slide, Lance teed it up nicely for us to talk about some of the differences between receivership and bankruptcy. So, as Lance mentioned, you can think of a receivership kind of on its own island, right? Just receivership, or receivership as a way to facilitate bankruptcy. So, I'm going to spend a few minutes kind of comparing the two before we talk a little bit more about why and how you may want to use receivership to initiate a bankruptcy filing. Like in bankruptcy, there is an automatic stay that is triggered by the appointment of the receiver under North Carolina law. And that's going to look a little different depending on the type of receivership. So in a limited receivership, it's going to be limited, of course, to the collateral. It's going to prohibit anyone from obtaining possession or interfering with that receivership property, or creating or perfecting new liens against that property. And it's going to be limited in time. So in bankruptcy, when a bankruptcy is filed, the automatic stay is immediately triggered and it continues for the duration of the case unless the court enters an order lifting the stay. In a receivership, that period of time is not indefinite. And so in a general receivership, if you would like your automatic stay to extend longer than 60 days, and longer than basically the 2 months after your appointment of your receiver, you'll need to move for an extension of that time. If there is no movement for an extension of time before the end of that 60-day period, the stay is going to expire, and that's going to kind of create a collection free for all. So perhaps the reason that you, or one of the reasons you put the entity into a receivership was to press pause on numerous actions and sort out what needs to be done so that you can be paid first in order of your priority. If you don't get things sorted, it's just going to be a free for all right back kind of where you started. Additionally, if there are particular situations involving your debtor entity, the receivership stay may not apply to those situations. And so those would be criminal proceedings, domestic support obligations, enforcement of a set-off right, and continuation or perfection of existing liens. The automatic stay will not apply to actions related to those things in a receivership under North Carolina law.
And Lily, if I can just interject, the other thing to keep in mind is that the bankruptcy automatic stay is nationwide because bankruptcy courts are federal courts. North Carolina receivership stay only extends to the borders of the state of North Carolina. The stay is not enforceable if there's something going on in another state. You'd be hard pressed to have that stay enforced in the absence of filing a separate action in that state to kind of recognize the receivership and kind of give it full faith and credit and get a, say you're in South Carolina or Georgia, getting a South Carolina or Georgia judge to enter their own independent stay of the particular action that you want to stop. So if you're dealing with a borrower whose operations are regional, for instance, you need to be aware that there's going to be some limitations on what kind of what you can tell the other creditors in the case who may be trying to collect outside of the state of North Carolina, and maybe that's an incentive for you to quickly get the case from receivership into bankruptcy.
Yeah, and to that point, Lance, the North Carolina Act expressly exempts bankruptcy filing from that stay. So if you're a limited receiver, you're subject to filing, of course, by management. Bankruptcy may be filed without violating the receivership stay. And then, of course, if you're a general receiver, you have the power to initiate that bankruptcy filing. Some other key differences between receivership and bankruptcy we have talked about. Of course, Lance mentioned that bankruptcy is federal, and this state court receivership is, of course, based in North Carolina or whatever state. Of course, we're talking about North Carolina today. And then in bankruptcy, the debtor in possession in a Chapter 11 case is going to keep management of the entity unless there is a trustee later appointed. And of course, in a general receivership, the receiver is going to displace management right off the bat. In bankruptcy, there is usually a discharge of remaining obligations of a debtor. In North Carolina, the Act does not provide for a discharge. So unsatisfied deficiencies are going to remain as claims against the debtor entity. Lance mentioned earlier that Chapter 11, of course, has a structured reorganization process that involves a plan, creditor votes, confirmation. The receivership does not have any kind of plan mechanism. There are certain processes that have to be followed in a receivership, but no plan concept in a receivership. And then, of course, as Lance mentioned, the automatic stay is broader at the bankruptcy court level, and then it is at the state level for a state court receivership.
And
So,
Lily, I'm sorry, I didn't mean to interrupt. Lily, go
no, go
ahead.
ahead.
Well, yeah, this issue of receivership versus bankruptcy, I'd like to make kind of 2 points as we near the end of our time. The first of which is that receivership is expensive. This should never be the special asset officer's first option, because it's a tremendous amount of legal work and expense that you are going to have to pay, that may benefit many other creditors, but you're going to be the one footing the bill. A receiver can be paid through the assets of the receivership. And if it's an operating company with revenue, then a budget can be created that includes paying the receiver. But to get a competent receiver willing to take on the job, they're going to expect you as the bank to guarantee their payment. They're going to be looking to you for payment, or they're not going to take the gig. So, borrower's going to be paying their own lawyers. They're going to be paying for the receiver. The receiver needs a lawyer as an additional expense to guide him, to help him with him or her with the reporting requirements, and other things, to comply with the statute, to file lawsuits, to prepare subpoenas, to investigate in a fraud case. Where did all the money go? Who has it? What can we collect? How's that going to take place? So those expenses are going to be borne likely by the lender as well. So receivership is it's almost a last resort. You kind of want to limit it to operating companies where there is some potential enterprise value, and the ability to sell it as a going concern. Um, uh, but it's not something you want to run towards if you just have a discrete problem with a borrower, and some collateral that you can realize on, and maybe have a deficiency, and go into state court and try to get that deficiency reduced to judgment. There, your normal toolbox is the tools in the toolbox, or what you want to turn to. But so the alternative to receivership is kind of pushing the borrower into bankruptcy. There's a benefit to getting a borrower into a Chapter 7 bankruptcy, which is a liquidation, because there your legal spend, by and large, stops. A Chapter 7 trustee is appointed, and then a Chapter 7 trustee has to do all the things that you would want a receiver to do: collect all the assets, sell off everything to pay creditors, investigate where all the money went, if there's fraud or malfeasance, file lawsuits, and you don't have to pay the trustee. The trustee is paid through what he or she collects in the case as an administrative expense. Now, uh, the trade-off, though, is that a Chapter 7 trustee is duty bound to, if it's a company that's operating, to kind of close the company as soon as possible and have it sold. Chapter 7 trustees are not going to be allowed to operate a company for a year or more. So that could impact the value of a sale. Like their remit is to liquidate as soon as possible. So it's kind of a fire sale mentality. And you're kind of at the mercy of the Chapter 7 trustee's schedule. This would be one of many cases the Chapter 7 trustee has, and sometimes they just get around to it when they get around to it. Uh, it can be a slower process than a receiver who's being paid monthly, who's going to be more incentivized to maximize value um, uh, for you. Just kind of things you'll need to think about if you find yourself in this situation.
Absolutely. And I think, to underscore everything that Lance has said, Lance mentioned some consequences if you file an involuntary bankruptcy and it doesn't go your way and the court dismisses it. Same thing with a receivership, it's not without risk. So you want to make sure when you are filing or moving to appoint a receiver that is necessary and is a justifiable task. If the court finds there's bad faith, you're going to face the same thing with damages and attorney's fees, potentially some punitive damages being awarded for a bad faith receivership filing. So again, want to make sure you're thinking through all of the implications of a receivership and what that might look like. And with that in mind, Lance, I'll flip it back to you for some additional takeaways so we can wrap things up. If Haley, you want to flip to the takeaway slide.
Yeah, I would say the big takeaways or your homework is not your homework, but if you find yourself going down a path where receivership might be an option, take a peek at your loan documents to see whether or not you have a receivership clause. And then if you don't, think about addressing it in a forbearance or loan modification agreement. Understand that if you get a general receiver appointed, the debtor, your borrower is not going to be able to go into bankruptcy. Um, you will have that control. Um, Recognize that you've heard the automatic stay all your life, but the stay in receivership is much more limited, both geographically and temporally. Um, Remember that the receiver is not your receiver. The receiver is an independent person whose fiduciary duty is to the entire estate. He or she works for the estate, not for you. Um, and getting back to cost, um, um, that I think I probably scared you about how expensive it can be, and you may be thinking to yourself, "Well, can I get paid back for those expenses?" Maybe. So I would say the first thing is you'd want to look at your loan documents, and I'm sure they have provisions about re making protective advances, recovering attorney's fees and costs, and you just want to start by looking at what the specific language in your loan and security documents say about what types of costs and attorney's fees are recoverable to see if they cover cost of receivership. If there's any doubt about whether it's covered or not, um, the receiver can borrow money to pay expenses. And so what we have done in other cases is um, to provide what is essentially DIP financing from what in bankruptcy we call DIP financing, debtor in possession financing, but post receivership financing to the receiver. So instead of just advancing money, we created in the form of an obligation that the receiver has to pay back, and that moves to the top of the list of things getting paid after secured debt is paid, it would be an administrative expense of the receivership. So you can structure it in a way that you're not just paying the receiver and it's unsecured debt that's going to be paid pro rata if there's any money to pay unsecured creditors. You can even secure those advances with collateral through there's a process through which you would lay out the terms to the court. We're gonna fund $150,000 of the receivership, and we'd like it secured by this a second deed of trust on this real estate. And you have a notice and a hearing, and if it's approved, then it's going to be secured debt paid at the top with other secured debt. That there is some uh, opportunities there to recoup some of your costs. But unfortunately, what I have seen is that oftentimes the biggest secured creditor who's leading the charge for receivership is the one who has to foot the bill, and all the other creditors are content to just kind of ride along and complain and bicker and want this, that, or the other, but are unwilling to pitch in the process. I think we are right at 1 o'clock, so that is 1 hour. I think there are some questions in the chat, Haley, for those who want to stick around. And I know Lily and I have time to try to answer any questions that people might have.
Yeah, thank you guys for being flexible. We obviously understand that if folks need to hop off here, and just a reminder, we're still recording, so that'll be available on the link in the recording. But we have a question directed to both of you. The DIP financing attractive in North Carolina? Is it attractive in North Carolina? Making sure there is nothing changed from the super prime you get on AR as collateral. DIP financing can be attractive to alternate lenders. I hope I did not butcher that question.
Yeah, no, Haley, I can take that one. Yeah, DIP financing or debtor in possession financing is when a borrower or I'm sorry, a lender is willing to lend money to an entity that has filed bankruptcy, Chapter 11 bankruptcy, but they need money to operate. And frankly, our judges like dip financing, and they don't mind if the terms are onerous. High rates of interest are expected because you've got a company often with employees who are trying to survive, and you have a lender who is willing to put money into the company, take a chance on this company. So yes, they can get a super priority lien, first money in, first money out, and they're well protected. And you do have to get court approval. There, you do have to have a notice and a hearing, and sometimes you might get some pushback from the secured creditor who's first in line on what your collateral is, if it's receivables or otherwise. Sometimes that can be negotiated outside of court with that secured creditor and their counsel, particularly if they have reached their limit and they're unwilling to put more money into the company. But yes, I would say that it's looked upon favorably by our bankruptcy court judges.
Thanks, Lance. And then we just had one more question. Could you do a Chapter 11 receivership type with the Chapter 11 trustee to spread the cost out on everyone?
Yes, yes. So sometimes you couldn't get your receivership in place. The debtor filed Chapter 11. They are running the company in bankruptcy, but they're also running the company into the ground in bankruptcy, and it has to stop. And when it has to stop, creditors have two options. One is to try to get three options. One is to try to get the case dismissed, but dismissal just turns into a free-for-all in state court. The other is converting to Chapter 7. So management is replaced by a Chapter 7 trustee who's going to liquidate the company. And a third option is appointment of a Chapter 11 trustee. And that is essentially a receiver in bankruptcy. The Chapter 11 trustee is not going to be appointed simply to liquidate the company. He or she is going to operate the company, and then a Chapter 11 trustee could actually put forth a different plan of reorganization. For instance, maybe you're like a franchise and you have 10 stores across the state, and five of them are profitable and five aren't. So maybe you could sell off the other five stores and then do a plan of reorganization that would just save the core business involving the five companies. So yes, a Chapter 7 trustee can be appointed. In those cases, the courts are looking for bad behavior after the bankruptcy filing. So maybe lack of financial transparency, not providing all the financial records that everybody needs to see, maybe a fraudulent transfer or money moving out of the company that shouldn't, just gross mismanagement, self-dealing, those sorts of things. But the court is really focused not on what got you into bankruptcy, but how have you behaved since bankruptcy. You file and you get all sorts of rights and privileges under the bankruptcy code, but you have to act in good faith and you have to act for the benefit of all of your creditors, and you have to be transparent and do what's right. And if you don't, then you will lose the right to run your company, and a court will appoint a Chapter 11 trustee.
Thank you, Lance and Lily. Well, we are over time and we're going to go ahead and wrap up there. For those in attendance following this webinar, probably tomorrow, you'll get sent email with a recording of the session. And then also with the slide deck, we did have to skip 2 slides today, but that will be included in the slide deck that we'll send out. Please save the date and look for another email for our next summer school webinar on Wednesday, July 22nd, regarding the first hours of Chapter 11 filing, with speakers Norman Leonard and Jameson Dahl. We're so grateful for your participation. We hope you took away some really valuable insights. That's going to conclude today's webinar. Thank you so much, Lance and Lily. Have a great rest of your summer, a great rest of your week, everybody.
Thank you, everyone. And on behalf of Lily and I, we want to thank Haley. We couldn't put these on without Haley's excellent work, technical and otherwise. So thank you, Haley. Thank you all for taking time, and we hope you all have a great summer. If anybody has any follow-up questions for Lily and I, don't hesitate to email us or call us. We will answer them off the clock.
Great. I'll send some emails right now. Thanks, guys. Have a good one, everyone.
Bye.